Hello and good morning. My name is Britten Sessions, and I will be giving the presentation this morning. As we start off this presentation, I think it would be good to just have a few brief reminders. So if there are any issues with hearing me or what it is that I'm saying, please let me know. Otherwise, I will assume that you hear me just fine. All right, so let's go ahead and begin with the slides here. Some other reminders, also, if you can please mute your audio. All of you should have your audio already muted, but if in any case it is not, please mute it. There will be a point in the presentation where if you want to unmute and ask questions, you can. In particular, as I go through the presentation material, if you have any questions, feel free to offer them via the Zoom chat box as well. Last but not least, as is indicated here, this is being recorded, so you will have access to it at a later time if desired. So with that said, I think that, every good attorney has to start with some disclaimer. And my disclaimer here is that the information within this does not constitute legal advice. As always, if you have specific questions on intellectual property, I encourage you to get those questions answered via an actual attorney. So with that said, just a very brief background on myself. I am a patent attorney, and I've had the opportunity to counsel everyone from individual inventors and small companies all the way up to Fortune 500 size companies as well. Been able to assist many with receiving and gross overall in excess of $100 million through patent monetization efforts. And I've been repeatedly ranked as one of the top 300 IP strategists in the world. Now you may think, well, aren't all kind of patent attorneys patent strategists? And that's not necessarily the case. As a patent attorney, I function in that capacity, meaning that I counsel clients on how it is that they can get patents. But an IP strategist actually takes a little bit of a different approach. They look at the business of patents, and they try to align patents with the business strategy. So I've gotten involved with many companies in the Bay Area, looking at how can you ensure that what you're doing with respect to protecting your IP coincides with the business goals of what it is you're trying to achieve with the business. And sometimes you would think that they should just align very nicely, but often they do not. They are often treated as two different vehicles going on two different roads. But the more that you can align the two together, intellectual property goes from being something that you don't understand to actually being an asset that follows and goes along with the actual business goals of the company itself. Have had the opportunity to write many different textbooks and books. I've also founded an IP clinic in San Jose. And have established multiple IP degree programs, masters, LLM, etc. So in short, I've had the opportunity to do many different things in the field of intellectual property. On top of that, I get to write and teach and be involved with a lot of neat inventors. I would note that perhaps given my teaching background, I like questions. And I also like when students and others and inventors throughout the area actually reach out to me. I've gotten involved with many different small companies and inventors, just assisting them with understanding what potentially could be pursued for their intellectual property. So my email address is indicated on the first slide, and you'll see it also at the end on the concluding slide as well. But I really encourage you that if you do have any questions whatsoever, feel free to reach out. So what are we going to be covering today? We are going to be covering a few different aspects. First off, I want you to understand the very basics of what is intellectual property. Sometimes, often when people come to me and say, well, I need a patent because I've created this book and I want to make sure that nobody is infringing my book, or I'm trying to create this business and this logo and I want to make sure that I get a patent on what it is that I have created. There's a lot of confusion often about what exactly is intellectual property. And the answer is, it's actually not that hard. But you need to understand what the clear dividing lines are between everything that is and isn't for each of the different categories. So my focus as a patent attorney, and as I indicated as an IP strategist, is to very much focus on what can we do so that we actually add value to what it is that we are doing. So that we will be looking at how it is that we can integrate strategies into the patent application itself. And we'll be looking at whether or not a patent application has been created well. We'll also look at how can you actually determine whether or not infringement is occurring on the patent application as well. So that's kind of an overview of what it is that we'll be doing with the discussion today. So first off, what is intellectual property and what are the different nuances of that? I think one of the easiest ways to look at this is just a clear example. So what you have here is an image. It's a part image of, in fact, a hammer, and it's just a regular conventional type hammer. And this is just to exemplify that often on everyday objects, there are multiple IP classes that are involved. So we have here the top arrow is pointing to what is perhaps not really seen very well, is an R in a circle. And that is in reference to a trademark, a registered trademark logo that relates to the logo Stanley. You also have on the bottom arrow that is pointing to specific patent numbers. So what exactly is going on here? Here are some other aspects of that. You have on the two left boxes that are showing the different configurations of the patent. Now you may be sitting there thinking, well, we're talking about a hammer here, and how is it that somebody has gotten a patent on a hammer that's probably existed for a very, very long time? And here it's not necessarily the patent is not necessarily on the hammer itself, it's on a specific improvement of the hammer itself. So it's actually, this is looking at reinforced jacketed handles. And so it's all about how are you actually cushioning the blow after it is that you strike and hit something. That's what this patent, in fact, in particular is looking at. So, but the patent is all about the invention. It's all about what has actually been created in some manner. So the patent is the invention. The trademark, when all is said and done, is focusing on the brand. So here on the right-hand side, you have the logo Stanley, and that is in particular referencing the brand Stanley. So when we think of trademarks, again, I want you to be thinking of brand protection. And brand protection can relate to logos, it can relate to names, it can relate to smells, I mean, it can relate to sounds. If you walk into a particular store, I'm sure that many of you have gone into a mall and there's very particular stores that you walk in and there's a specific scent. That scent is likely trademark, right? Why? Because when you walk in there, you smell it, it automatically makes you think of a particular brand. So trademark is all about brand protection, logos, words, things of that nature. There are other two aspects of intellectual property. The third one would be copyrights, and copyrights refers to what are called creations. And creations often can include almost anything. It can include a sculpture, it can include a manuscript. Within the context of what we're dealing here with the hammer, the patent is looking at that which is new, the invented aspects itself. The trademark, again, is looking at the brand protection. The copyright could be a website that is, in fact, indicating information, content, text about, let's say, user manual about the hammer. Or it might be a website that, in fact, has steps on how you can, in fact, purchase it yourself. So when we talk about the different aspects of IP, again, patents, inventions, trademarks, brands, copyrights is content. Last but not least is trade secret. And trade secret, as the name kind of applies, is a secret. You keep it a secret. Now, you may be wondering, well, why would we ever want to keep something a secret? And usually it comes down to something that gives you a competitive advantage that is not readily determined by whoever buys your product. So if you have a product, and let's say that, I'm creating this microphone And in creating this microphone, I use a very specific process to, let's say, create some of the electronic filaments that are embedded within the microphone itself. If somebody dissects and takes apart that microphone, they can't really figure out how it is that you connected everything together. It's a perfect example of a trade secret, or something that should be potentially kept as a trade secret. If it gives you, the company, a competitive advantage, and you can't really determine how it is that it occurs in the final product, that's usually something that's a good thing to be kept as a trade secret. So again, this is your 30-second introduction into intellectual property. But again, if we review this one more time, patents relate to inventions, that which is new, and that could be a new method, it could be a new apparatus or system. Here again, we have a specific, this is called an apparatus. I'm talking about a hand tool or a jacketed handle. We also have the trademark that is looking at the brand protection, that which is actually selling the product or the improvement. We have a copyright, which often relates to content, descriptions, manuals, things of that nature. And we have a trade secret, and perhaps there's a trade secret for this hammer. We will not know, and that's kind of intended, whether or not a trade secret is in fact existing. Now, there are some known trade secrets out there. The recipe for Coca-Cola, or the recipe for Kentucky Fried Chicken, or there's a lot of recipes are often kept as trade secret. Yes, we can try to reverse engineer and copycat and things of that nature. And that's one of the reasons that we can figure out. But to a certain extent, we don't know the exact steps that they say creates the perfect end product. So again, if you have any questions on the basics of intellectual property, feel free to put it in the chat box. Otherwise, let's move on. All right, so what are patent strategies? And now we're going to kind of transition. Let me get water 1 second. So what are we going to do with respect to patent strategies? Now, a bulk of the rest of the lecture today is going to be focusing in particular on patents, inventions that are new and not obvious. And so when we talk about patent strategies, this is where I really get passionate, because it's almost the business side of patents themselves. Now, often when people try to get patents, they think, well, I just need to protect my invention, make sure that nobody comes after it. And I would say that's a level 1 type view, making sure that you have some form of protection. But if that is all that it is that you're viewing a patent as, you are really selling yourself short of what it possibly could be. So what exactly is a patent, and how can it be used for more than, let's just say, protection type basis? Now, when we talk about patent strategies, rule number 1, as I indicate, is that simplicity wins. Now, the reason for that, and I do not necessarily indicate or mean for it to be interpreted that your invention has to be simple in order to get patented. That's not my point. My point is that how it is that you describe something needs to be done in a manner that anybody can understand it, even if it is a very difficult and complex invention. And the reason for that is who, at the end of the day, is going to be evaluating whether or not your patent is even valid. And it is not necessarily a judge or somebody with an engineering degree or anything like that. At the end of the day, it is a lay jury, a jury that is composed of everyday people from off the street that will be evaluating your patent. And so in view of that, if you go ahead and try to describe your invention in the most complex, complicated words, well, to a certain extent, that's going to be that much harder for a regular lay jury later on to try to interpret whether or not, and to determine whether or not your patent is in fact even valid. So it doesn't matter what strategy it is that you go down and what it is that you employ as far as using your patent, keep in mind that the manner in which you describe your patent is often either makes it or breaks it, as they say. And I think that one of the most interesting things is you have often found and talked to others that are extremely intelligent and can understand very deep things. But whether or not somebody can understand that is one point. The other point is, can they convey it in a manner that anybody can understand it? And that is a real art, being able to take complex things and describe it in a manner that anybody, in fact, can actually understand it. So again, simplicity wins. And it looks like there is one specific question. Mitchell, do you have one on details and conception or conceptual?
Conceptual, yeah. I wanted to find out, when you're saying about in simplicity also, if you give something in the most general sense, because like if you could say, oh, I've got this design and it uses LEDs for this method to get something done. But if it's possible, there are other technologies to say a light source will do this, so that you're going at the concept of what you're doing rather than any details on the exact method. Like if you say also a format of a file, you're going to have to have a file that records something. You just say what it stores, but nothing about the format whatsoever, to make it more abstract and conceptual.
Yeah, and usually the strategy with respect to detailed versus conceptual is yes. And what I mean by that is you usually want to cover both. You want something that is conceptual enough that the average everyday person can understand what's going on, but by no means should you minimize the amount of details and actual examples and embodiments that you're putting into your patent application. You want the conceptual as kind of think of it as a marketing poster that you can walk into a courthouse with and say, this is my invention. And you want it for that purpose. But keep in mind, before you even get to go to determine whether or not your patent is still valid before a jury, you have to go, in fact, through the technical process, through the patent examiners, and potentially even through the USPTO PTAB. That's the appellate board for determining validity of patents. So the ultimate arbitrator of whether or not your patent is valid is, in fact, the jury. But before you get to the jury, you have the technical experts. And so that is why it is that you need the ability to include both the details and the conceptual, because you in fact have to meet both parties and the needs of each. All right, so here, this is kind of a pictorial representation as what can a patent actually be used for. And so when we talk about initial protection, you see here, I use the castle analogy, and forgive me, but I lived in Europe for a number of years. I was surrounded by castles. I love castles. They're absolutely beautiful, but I think that it really provides a very clear example of how it is that patents can be used. So a castle ultimately, or at least initially, is being set up so that it protects something in the inner core, treasure, people, things of that nature. And that is often how it is that we start out thinking about patents. I want to be able to protect myself and or my invention. So when we think about, again, the castle analogy, it's that which is within the walls that we're trying to protect. But a castle, and the defense of a castle, and perhaps the offense, there is both a defense mechanism and an offense mechanism. You have the defense of the moat around it. Patents can be used to defend yourself if somebody comes against you. In addition, there is also the ability to go offensively, where you can, in fact, have artillery or other things like that will simply allow you to go on the attack if somebody is coming against you. Now, that in fact kind of sounds a little bit contrary. You have, for example, the ability to defend yourself if somebody is attacking, but in like manner, there is the ability to actually go on the offense if necessary in actually defending yourself. So defending can be if somebody's coming against you, or defending in the sense that you are proactively actually going out. A patent can be used to defend if somebody's coming against you, or it can be used to proactively go out and assert your rights that relate to your invention. And last but not least, a castle, the stronger your castle, the higher the likelihood that you will be able to form allegiances with others. I scratch your back, you scratch my back. And that is, in fact, often what occurs in the world of patents. The bigger your castle is, the more patents you have, Often it can be used to form alliances with other companies. It's kind of a peace treaty. I won't sue you if you don't sue me. Or let's team up together and we can go against a big gorilla. So the idea of how does this all occurs is often, I think, fascinating. So let's look at this just a little bit more. When we talk about our inner core of the castle, I call that core technology. When I talk about market protection, that is often looking at where it is that other players are going in the market and how it is you're responding to that. So this are often our allegiances, alliances with other within the market. Often said in defensive, or again, as the name implies, whether you're using the patent in an offensive manner or a defensive manner. So just a few little details on each of these. Now, I should note, actually, before I go into the details, that when we look at patent strategies, often when I go over this, sometimes inventors come away and say, wow, that means I need essentially 4 different patents to do 4 different purposes. And the answer is no. You can have one patent and it can be used in the 4 different ways. In fact, you can have one patent that has a very long claim set that can hit all these different strategies. So it is simply a vehicle as to how it is that the patent is being used. And that's a key point that I want you to come away with. A patent can be constructed in a manner where it hits all these strategies, but that's the key. Often when a patent is being constructed and put together, it is taken from the point of view, usually of just the core technology, trying to protect the core technology itself, of our inner treasure within the castle. And we really don't look at what the other players are doing, or we do not anticipate how we may use this in a defensive or offensive way. But you can cover all of these within a single patent application. And that's the point I want you to come away with. If you prepare the patent application right, you can use it for all of these. If you do not prepare the patent application right, then you may be confined to only using it in a singular manner, which may not necessarily give you the best value with the most options later on. That's the big point that I want you to come away with here. So core technology patents are often looking at very particular aspects of the invention itself. And so in all reality, we have the ability to actually look at narrow claim sets. The narrow claim sets, again, are directed towards very particular aspects of the invention. I'm going to go through these relatively quickly, but I want you to look at it from that point of view of, if I'm doing a core technology, it's a very small subset of my overall invention. Market protection patents are looking at how it is the market will play out 10 years from now. So this is very much thinking outside of the box of where are things going and where do I expect them to go. And in all reality, it's a gamble. You don't know how the market's going to respond or where it is that they're going. But the more in depth you can actually describe where it is that you think things are going in the future, the better it will be. Offensive, defensive, again, just allows you to protect yourself. And this comes down to having claims that are sufficiently narrow, but also sufficiently broad. You don't want a claim so broad that it covers everything in the world. Why? That usually is easy to overcome in the sense that you can invalidate that claim. The more broad it is, the more prior art there is that can invalidate it. But if your claim is so narrow, going back to our core technology example, if it is so narrow, then there may in fact never be anybody that infringes it. So there's this sweet zone of having something that is sufficiently broad that it does encompass many players in the market, but not so narrow that it prevents infringement. So there's this, again, this sweet zone of not too broad and not too narrow that is what it is that you're looking for. Now, when we look at, again, going back to our example here, what are some pragmatic realities of what it is that we want to achieve? And what we want to achieve is essentially a very robust specification. So your patent application is comprised of a lot of text, and your specification is the bulk of that text. And the easiest way to kind of think about it when you're approaching it is the more content you have in there, the better it sets you up to have as many options for these different strategies in the future. A standard patent application might be in the range of, let's say, 15-20 pages. And that would be kind of a standard type length. But what if, let's say, you had a patent application that was 50 pages or 100 pages, or I've written one patent application that was 600 pages. That's a lot of content in there. And if we think of it from that point of view, everything that you provide in there is potential land that you can claim as your own. And that is a very important point. And what I mean by that is often people think, well, my patent application, the protection I have is governed by everything that I have within the patent application. And the answer to that is actually no, it's not. You get protection off of your patent claim itself. Let me repeat that. You get protection based off of your patent claim. So when we're looking at this land that you're disclosing within the patent application, the land literally may be your entire territory that you own as far as property rights. But your claim may represent just a small fenced area on your entire land. So from a patent point of view, if you were to assert your rights, you can only assert rights based off of your fenced area that you have claimed is your territory that is protected. Now, within this land type aspect, you can get multiple different claimed areas. You can have multiple different fences, multiple different things. You can have a fence within a fenced area. And that's where all these different strategies come into play, because you might want a fence that is butting right up to where it is your competition is. You might want a fence that's in the very core part of what it is you're doing. You might want a fence looking at where it is these may be going in the future. So you have all these different fenced areas, and that can correspond with each of your strategies. So the question is, how do you integrate this into your actual patent application itself? As I indicated, patent strategies focus on how it is you use, but obviously how it is that you create the specification and the claims dictates what strategies you have later on. So let's talk about claims. When you want to set up your patent application to be able to have as many options as possible, you want a variety of different types of claims. You might want a particular claim set that is a little bit more broad, a particular claim set that is a little bit more narrow, and you might want everything in between as well. What that usually translates to is you might want to have one patent application that has a narrow claim set, and then you file what's called a continuation, and that gets the benefit of the original filing date of what it is that you filed. And in that continuation, you can put forth a new type of claim set that allows you to essentially cover different ground. And in this manner, that can be replicated over and over and over again, such that you can have all these different claim sets with different types of scope. The specification, in order for us to have the options to pursue all these different types of claim sets, your specification needs to be robust. And this goes back to the land analogy. The claims represent the fenced area of the land. The specification represents our land. And so we want to make sure that that specification is deep. As I often go in as a patent, I'm also an IP financial backer. That's not early stage IP financial backing. That's usually later stage IP financial backing. But the point of that is that when I go in and evaluate companies and their patents, often what am I looking for? I'm looking for an original file name that claims priority to essentially a technical manual. Because the technical manual often is 1,000 pages, there's a ton of ability. There is a ton of ability to actually pursue all these different types of patent strategies just because the land is a lot bigger. And if the land is a lot bigger, this simply opens up a lot more options that you can actually pursue. So specification, you want as many examples as you can in there. You want to be thinking what you are doing alive and what is going on in the future. Now, this last point is keep your patent alive. This is perhaps a common term within the patent industry, and what that relates to is when you pursue a patent application and you get that patent application, let's say allowed, meaning that your patent is going to be granted, you have an option at any time prior to actual issuance of filing what I indicated before, a continuation. That is what is called keeping your patent alive. If you do not file a patent continuation, then what ends up occurring is that once your patent actually issues, it ends. And what I mean by ends is your ability to modify the claims is greatly restricted. Now, what I mean by that, in short, is that if your ability to modify the claims is restricted, then you, in essence, do not have the ability to modify the patent strategies later on. And you may think, well, why would I want to? A patent reaches usually its peak value around 10 years after initial filing. So you may be spending years 1 through 5 trying to get as many patents as you can on the invention, and you may be thinking, all right, we're done now. At the 10-year mark is where it is again that a patent often is reaching its peak value. And the reason for that is it's usually the market is 10 years behind new ideas. The market finally comes up to speed, starts implementing much of what it is that perhaps you have invented. And at that point, the question is, what do you do? If you do not have a patent alive, meaning that you do not have a continuation pending, you are only able to show infringement if you got it right in your initial patent claims. Meaning that if you anticipated where the market was going to go, and if you played that gamble correctly and you got it right, then you're good, you're a gold mine. At the end of the day, very few people actually get it right directly 100% on. So what ends up happening is that if you do not have the ability to modify your claim, you're stuck in the mud. You do the best that you can with what it is that you've been granted, but if somebody has designed around your fenced area, they have a little path around it, then there's no infringement, and nothing you can do can prevent that. On the other hand, if you have a patent continuation pending, you can go back in and modify that claim so that you can show the actual infringement that is now occurring with the marketplace nowadays. This is simply to mean that your ability to modify the patent claims is usually linked directly to your ability to pursue patent strategies. If you aren't able to modify the patent claims, then your ability to pursue different patent strategies is greatly limited. So if you want to keep those options open, keep your patent alive. When it comes up for a grant, just keep that in mind. So let's look at a brief example here. We have something that hopefully all of you have seen before, a pencil. And the question is, if you are going to pursue trying to protect and claim a pencil, how would you do that? So you can look at the different parts and classes of your invention. You can look at how it is that they are actually connecting together. If we were looking at this from a core technology point of view, you can see that I have very narrow elements: a writing instrument, elongated cylindrical rod of graphite, wood surrounding the graphite, rubber eraser, things of that nature. It's very precise. But what if we wanted something that was going more offensive and defensive? Well, do we want something that expressly indicates a cylindrical? What if it's not cylindrical? Do we want to specifically confine that to just graphite or to wood or a rubber eraser, etc.? And my point is, if we have a robust specification, we can look at the problem that is to be solved and have a lot more flexibility. If we only look at this as a parts construction, then what we've done in core technology, again, is kind of step one, and that's where a lot of patent attorneys kind of leave it. But if we take a step back and say, well, the problem to be solved here is some type of a writing element that allows them to write on some type of surface. Well, let's take a look at that. On the left-hand side is an example claim that would be kind of a core technology claim. You can see that it's very precise, is specifically indicating what is within the invention itself. Now, if we were going for an offensive defensive, This is kind of an extreme example, but it illustrates what it is, the point that I'm trying to make. And that is, rather than saying a writing instrument, you can say a product. Rather than saying specifically an elongated cylindrical rod consistent of graphite, you can just say an inner portion. We have an outer portion, and then the offensive defensive claim concludes with the inner portion is configured to mark a surface in contact therewith. So it's looking at kind of very much the problem to be solved from a very broad basis. Now, I do not mean to suggest that this is the best type of claim for an offensive defensive use, but you get my point. There's two different types of claims here, one that's more narrow and one that is more broad. And that is the point I want you to come away with. The ability to show infringement is directly dependent on your ability to show meet each and every single limitation of your claim. If our claim was on the left-hand side, and let's say we did not keep the patent family alive, if somebody else came along and was using a different substrate, let's say they were using graphite, they were using something else, we would not be able to go after them for infringement. But if we had a continuation still pending, we could go back in and broaden, for example, the specific substrate that is being used to mark the surface. So your ability to modify the claim is directly linked to your ability to actually show infringement. Now, I think one other thing to keep in mind, sometimes this rubs inventors perhaps in the wrong way. They say, well, does that mean that we are going back in 10 years after the fact and reinventing things to now show infringement? And the answer is a big no. You are not reinventing and you are not adding anything new to your original specification. Keep in mind, the original specification is the entire land. You cannot modify that land after you file it. So if you file it 10 years ago, it's still the same. It is everything that you claim, or rather, that's a wrong use of terms there. It's everything that you have disclosed relates to your invention. Your claims have to come from that entire corpus of material. You can't add new material to that, but your claims are not new material. As long as they have a solid basis from that which was disclosed initially, you're in the good. You can go ahead and modify your claims however you want, assuming that you have kept the patent application alive. You can see here, here's another example. This is from a professor, Professor Frommer. And she indicates here two different types of claiming strategies. And she calls it central claiming and peripheral claiming. Central claiming would be akin to what I call core technology. Peripheral claiming would be offensive, defensive, market type strategy claiming. Looking at things from different perspectives, broadening it up. So again, that's just another contextual point for you. So when we look at the strategy specifically for the specification, there are some questions. Have you made it robust enough that there is the ability to potentially broaden the claim? Have you only disclosed that the writing device uses graphite? Or what if it's using something else? So your ability, this is where all the different examples come into play relating to your invention. Have you disclosed those examples in a very clear manner? And the key point here is, have you not only disclosed the core invention, but all the different ways that it may be potentially implemented? And when I talk to companies, I often ask them, okay, I'm interested in what you have invented, but tell me how your invention may be modified. Tell me 10 years from now, how do you anticipate somebody might use your invention in a new way? So thinking outside of the box from just the absolute core invention allows you to anticipate how potentially infringement might occur, and you get all those examples in there, and that kind of builds up your specification. In implementing these types of strategies for claims and for specification, remember two things, or actually three things as I indicate here. Claim diversity, you want a diverse set of claims. Second, you want a very robust specification, meaning you have covered the core concepts and all the peripheral things relating thereto. And last but not least, keep your patent alive. If you want to pursue patent strategies, it is vitally dependent upon you being able to actually have the option to modify. If you don't have a patent alive, there is no option. So keep your options open to the extent that you can. So let's move on to the next subject, and that is, how do these strategies actually influence the value of your patent? Now, there's many different calculations and equations on how it is that you actually value patents. And I'm not going to go into any of those rather philosophical and very intense discussions as to what is the basis for it. This is, yes, yours truly, my one and only, very simple patent value formula. And what is interesting is that in almost all the different computations out there to look at the valuation of patents, there is elements of both of these in almost all of them. And what I indicate is a two-part process, looking at the logistics and looking at demand. And I think a very way to look at this is to no longer think of IP as some intangible aspect. Let's talk about it in the context of a physical property. Physical property itself, often the pricing is based off of how nice is the property, how well was it built, and where it is located. You may have a dump of a house, but if it's located in Palo Alto, that's still worth $1 million. And you may have a castle of a house, but it's located in the middle of the desert where nobody's going, and it's worth nothing. So being able to have nice house in a good location is where there is maximum amount of value. And it's the same exact rationale for a patent. Logistics just simply comes down to how well was the patent put together? Is there a robust specification? Are there options for the claims? Demand simply comes down to, is anybody in the world actually using the invention? So those are two aspects, and if you can meet both of those, then there is significant value for your patent. Now, here are all the different types of aspects that I often look at, trying to assess value within portfolios. Strategies relating to the breadth of the claims, as we've talked about, the depth of the prosecution process. Have you just kind of skimmed the surface with the patent examiner, or have you done a real robust type analysis? So these are all different considerations. A file wrapper, for example, you may not be aware of that term. Every correspondence that you have with the patent office, at least back in the day, was stuck into a specific manila type folder. And that became your file wrapper, is wrapped together of all the communication. Now they have it in digital format nowadays, but they still call it the file wrapper. But if you are making arguments to the patent office of how it is that you're construing specific terms, that can in fact affect the value, because you can limit how it is that your terms are actually construed. So being able to understand that everything that is going on now is will affect potentially how nice your patent is later on is simply the main point that I want to make. The clear showing of infringement simply comes down to what I call claim charts, and I just don't call that. That's the standard term within the industry as well. We'll be looking at that as well. All right, so has it been created well? And then again, this is looking at the strength of the logistics of it itself. We've talked a little bit about the breadth of the claims and the specification. Live family members, it just simply looks at whether or not there is still a patent application that is pending, by which you can modify the claims to make the changes that you want. When we look at a file wrapper, what are you looking for? You're looking at whether or not any statements were made that may limit, and this is a legal term that's called prosecution history estoppel, which simply means that if you have claimed that your microphone cannot be construed as being the color black, and you are now trying to later on say the microphone can be any color, your argument previously made will stop you from making a contrary argument in the future. It's kind of a blunt example, but it simply indicates the point. The arguments you make may prevent you from showing infringement in a different manner later on. So in the main thrust of this is you want to ensure that your arguments are consistent then and now. And the last one here is if no statements were made to the examiner, is that necessarily good? I have had some patents, for example, where I file for them and we get the patent allowed without a single rejection from the patent office. And sometimes the client says, well, whoopee, I got my patent and there was absolutely no fight whatsoever. Well, sometimes that's not necessarily the best thing. Because what that means is that your claim was so narrow that there was no applicable prior art. So often what patent practitioners do is they will purposely go a little bit more broad in their claim than they think is necessary. Why? Because then prior art will be presented and rejected to reject the present claim, and you can modify the claim to butt right up next to that prior art. So if you simply go through the patent prosecution process and there's no dispute whatsoever, it should be perhaps a yellow flag that maybe you should file a continuation and broaden your claim a little bit more so that you do get some prior art. So there is some fight, so to speak, so that you know where the prior art is and you can actually put that fence line right up next to where it is that the patent office is saying protection currently exists. Now let's look at timing. Timing itself, if a patent is too old, keep in mind that a patent only gets protection for 20 years, or rather an invention only gets protection for 20 years. A patent grants you a temporary monopoly, but it's not without time. You only get it for that 20-year period. And so if you, let's say if the market starts coming around, you're 15, you're 18, and now they are starting to infringe. Well, the older the patent is and the closer you're getting to that 20-year mark, your ability to recoup for current damages goes down. You might be able to, let's say that you're at the 20-year mark, you can still show infringement, but you would only be able to recoup past damages. So that's one of the reasons why, again, that 10-year mark is kind of just a rough rubric. That once you're at that 10-year mark of a patent, then you're kind of at that peak because you're not too new and you're not too old and the market is catching up. Now, within the context of patents, I indicated to you that we need to make sure that we keep our patent family alive. But how do we do that? Well, we file a continuation. Every time you file a continuation, it creates almost a link to everything that preceded it in some manner. And that those links are what's called a patent priority. And so if you have, let's say you file 3 continuations, those 3 continuations will claim priority all the way back to the initial patent application that was filed. Those continuations do not expand the 20-year coverage as far as protection is concerned. Keep that in mind. All you get is the benefit of the initial filing date, and from that is calculated the 20 years. So a continuation does not grant you any additional patent term. It only grants you additional, shall we say, arrows in your quiver by which you can show infringement. So that's an important point to keep it alive, because then you can modify your claims, but it has absolutely no effect as far as extending actual patent term. Patent parents are just simply that which precedes the original patent application, and a patent child or patent children are those assets that come after it. And I see that there's been many questions on recordings and slides, and yes, I will make it all available. All right, so how do we show patent infringement? Now this comes down to what are called claim charts, and this is a real, let's say, easy example. Our invention here is a table. So you can see a table includes surface, one or more support legs, and one or more attachments that are essentially angled down, or they're 90 degrees to the surface itself. So that is, if that were our invention, how would we actually show infringement? Well, here are 2 possible infringing devices. We have one that has 2 legs and one that has a single leg. And you can see it going back to the claim on the left-hand side, a table which comprises a surface. They both have a surface, 1 or more support legs. Well, there is 1 or more support legs on each of these, and 1 or more support leg is attached to the surface, and it essentially is at 90 degrees down. So both of these would be potentially infringing devices. How do we show that? Well, you create, again, a claim chart. A claim chart on the left-hand side generally has the claim language. On the right-hand side is to show the applicability of that language to that which you are saying is infringing. So again, on the left-hand side, we have, if we go down to the second row or the third row, a surface. On the right-hand side, we have an arrow that points out the surface. Going on, one or more support legs, we have arrows to the support or show those support legs. And then the last element there talking about is orthogonal to the surface itself. Again, we kind of circled where it is that is occurring. So this is a very simple claim chart. But when you look through it, in short, what you're doing is taking the limitations of your claim and showing how the potentially infringing product meets each and every single aspect of those limitations. This is a very simple claim chart, but this is this shows and is consistent with what is actually submitted to the courts during a litigation process. And so what I mean by that is, as you're going through a patent litigation process, nowadays you need to have these charts done, generally speaking, even before you file a lawsuit. The laws have changed over the years, and right now the burden is on the person that is bringing the lawsuit to show that they have a solid basis to bring it even prior to bringing it. An easy way to do that is to have what are, Rule 11, that's Federal Rules of Civil Procedure, Rule 11, that essentially shows that you have a substantive basis for bringing the lawsuit. So again, claim charts is how it is that we show infringement. So to recap again, we look at how nicely the patent was created, looking at the claims, looking at the entire land of what was disclosed, looking at the arguments that were made throughout that period, looking at whether or not something has been kept alive. And that is kind of the quality of our patent. And if that quality is good, and we have claim charts to show that infringement is occurring, that is showing the demand, then our patent is worth something. And that is, again, the real simplistic way of looking at this. If the patent was built well, and the patent now is being infringed in the marketplace right now, then our patent, again, is worth something. Now you may be wondering, well, how much is it worth? Well, that's a damages type analysis. During patent litigation, damages experts are usually often one of the highest paid experts. So I do not necessarily calculate an exact number here. But what I will indicate is this gives me a thumbs up or a thumbs down as to whether or not I have something of value. If it's actually determined that it was created correctly, thumbs up. And if there are multiple claim charts that actually show high level of infringement, and by high level, I'm meaning it's not just something that is going to affect, let's say, 10 devices, and each device is at $1,000, but let's say that it's in every single smartphone across the entire world. Well, high demand, and if we can show claim charts for that, then there's, again, a high basis for damages. So if it's created well and the higher base for damages with a clear showing of infringement, we get 2 thumbs up, and that tells us, all right, we have a good basis here. So we have roughly about 7 more minutes, and I think we have time to go through just a few remaining extra slides that I have here. I had them just in case we had extra time. At 10 o'clock, I'll turn it over to you where we can answer some of your questions. So we have gone, if we, again, kind of look at the entire basis of what we've been discussing over the last hour, and I recognize we're going kind of fast here. We have discussed all the different forms of IP, patents, inventions, trademarks, brands, copyrights, contents, and trade secrets. And then we've been looking in particular at patents themselves. And how do we ensure that our patent is actually worth something? In order to make sure it's worth something, our land, our disclosure needs to be very robust. Our claims, our fenced areas need to be precise enough and strategically placed enough on the land that is actually giving us the protection that we want. And the value, looking at the value, comes down to a combination of how well all that was put together and whether somebody in the world is actually even using that. So if we do have 2 thumbs up on value and we can proceed forward, then you look at monetization avenues. With respect to monetization avenues, again, if infringement is shown, what are your options? Most people assume that if they are going to go down the infringement route, it is automatically and only litigating. And I would say more often than not, it is litigation, but it is not just litigation. I will indicate that no matter which route you take, you should prepare your case as if you're going to be litigating it. So if you go down what I call the brokerage route or the licensing route, you should still go ahead and prepare your case as if you're going to litigate. It will be in your best interest. That means that if you go ahead and actually, you should create clean charts that show the potential infringement that is occurring regardless of the route that you're taking. Why? Because that just simply shows demand. The higher demand you can show, the brokerage route would hike up the price more. So litigation is where you're going to the courts and asserting your rights. Brokerage is where you go through a neutral party. You can think of it as the Switzerland approach. And brokerage is where you go to this third party, and this third party becomes essentially a marketing salesman for your portfolio and lines up potential interested buyers, bidders, things of that nature. There's also the licensing route, and that is where you, in a non-litigation setting, approach a company and say, I think you owe me a license. Now, that used to be a very effective way of doing it 10 years ago. Currently, there is not necessarily a lot of information that relates to that. And what I mean by that is the licensing route, it has grown out of favor because there's been a lot of defenses that have been provided to patent defenders such that they can in fact go ahead and actually defend themselves and try to kill the patent repeatedly, which simply means they are emboldened not to license in a non-litigation context. So litigation, again, is where you go to court. Brokerage is where you go through a neutral third party. Licensing is non-litigation. Now, with respect to litigation considerations, this gives you, again, this is from almost 10 years ago, but it is still valid, and that's why it is that I still include it. If you're going to go down the litigation route, the biggest question is, do you simply have a few million in the bank that you can use to assert your rights? If you don't have a few million in the bank, then you can't assert your rights, which means that can you potentially partner up with a funder to provide for litigation costs so that you can pursue your rights? That does occur in today's market. Back in the day, again, 10 plus years ago, there used to be a lot of litigation teams that would get involved purely on a contingency basis. That's not the case nowadays because the risk of asserting patents is a little bit higher. So the need to have funders and lined up funders for litigation is something that would need to occur in today's market. Not only that, but litigation is expensive, but also how you play the litigation team or the litigation game is not always the same. You may have heard that Western District of Texas, or rather the Eastern District of Texas, is kind of the gold mine for patents if you are to assert. Well, it used to be. It's not necessarily that way now. Nowadays, it's actually more, or at least it was for a time within the Western District of Texas. But there's different strategic reasons why it is you might want to go to Pennsylvania or Delaware or Northern District of California. There's reasons why it is you may want to go and file your lawsuit there for strategic reasons. Last but not least, we have the brokerage considerations. This can be, in fact, a real viable method. This is where, again, you're going through the Switzerland neutral third party type approach. There was the sale of the Nortel patents many years ago that sold for $4.5 billion, and that was through essentially a consortium that was functioning as a broker. You had the Motorola sell to $12.5 million, or actually $1 billion. Sorry, had that off. And that was, again, Google was trying to acquire and build up their patent reservoir as much as possible. They were a little low on the patents, wanted to make their counsel more robust. They acquired those from Motorola to make it more robust. Licensing, a lot of this is kind of the name of the game. And what I mean by that is your name allows you to have game. If you're a Motorola or you're a Qualcomm, your name essentially allows you to open doors for licensing. If you're a small peon and nobody really knows your name, there's not much of a threat there. And so that's sometimes, can you actually effectively go through that? And the answer is yes, but your expectations need to be correct. If you go down the licensing route nowadays, you might have to lower your pricing amount to overcome a, let's say, an initial threshold level, where now you can say, hey, we have 100 licensees to this portfolio, and at that point you can start increasing your price. So there needs to be realistic expectations of perhaps starting smaller as far as licensing amounts, and then you can ramp that up once you have a threshold number of licenses. So those are some of the considerations for monetization routes. Again, that's a very high level type approach. I've written books and have taught entire courses on the subject. The time is now yours if you have specific questions. I'm looking at some of the questions that have come in. I will deal with those questions first, and then if you have any further questions, we can go ahead and attack those at that point. So the first question is, what about multiple patents for broader inventions that may become a system of a few major standalone components? For example, a new television and a new camera to record the needed data for it. Well, this actually kind of is the problem with what is often called the smartphone wars. And that is that you have many parts that are all under the same essentially housing type component. You have a camera, you have a wireless system that allows it to connect with, you have a screen, you have a often a fingerprint sensor, you have all these sensors, you have a gyroscope, you have an accelerometer, you have all these sensors that are working on harmony, all these discrete parts. And the question is, what do you do? When the more parts and components you have, yes, you can break this down into a part by part composition and try to kind of piece everything together in that manner. But the more complicated it is, that means that you can literally have hundreds and potentially even thousands of patents while trying to cover a single device. So a good approach to the more complicated or the more component-based aspects we have is to, in fact, take a step back and ask yourself, what problem is trying to be solved here? Is the problem to be solved one where we are trying to just put into one framework everything that exists under the sun? If that's the case, it's kind of a broad problem. But if what we're trying to do is create a mobile multimedia device that allows user to have specific interactions, that's a very specific problem. And once you've identified the problem, then you can then focus your protection based off of the solutions to that problem. So it's not just the fact that you have all components that's under a single housing that is often the focus. The focus is usually the problem to be solved, some type of a multimedia device, a communication device, things of that nature, so that you are empowered to do more as the user. So again, you can have this, you can break it down by discrete parts, but I think often the better solution is to look at it as the problem to be solved and what are specific solutions to that problem that you're trying to overcome. The next question, when a patent examiner keeps looking for prior art to deny a patent, and the question is, can the patent examiner keep searching for prior art with no end in sight? It's a great question, and it is one that often will arise and occur, and that is simply the patent examiner is just drawing the process out, and every time you've overcome that prior art, the examiner then puts forth more prior art. Now, there's a lot of patent strategies that can be employed here. The first is if you go ahead and modify your claim to get around the prior art, If you take new parts of your land and incorporate them into your claim that were not in your claim before, that is statutorily the basis for which the patent examiner can now go out and look for new prior art to rebut the new things that you have incorporated. But let's say the examiner has rejected the claims and all the claims, and what you've done is you think that one of your dependent claims is not met by the prior art. And so you incorporate that into your independent claim, and your argument is that all you have done, you have not brought in anything new from the specification. You've just incorporated that which is already within the claim itself that is not being taught by the prior art. That is a different basis. And the basis is that if you have not brought in new stuff from the specification, then the examiner is not permitted to go out and look for new prior art. So that assumes, for example, that you have a non-final office action and things of that nature. If you have received a final office action and you are responding via an RCE allows the examiner to do a whole new patent search when you submit it. So there's every time you submit a new application or a new continuing request via an RCE, the examiner can do a whole new another search. But within the compacted prosecution process, namely you submit, you get an office action response to respond, and you get another office response. Those office responses are often only linked to that initial searching that was done. If you do not bring in new material from your land into the claims, then the examiner is restricted to only confining their arguments to what it is they initially searched. But if you are bringing new elements from the claims from the specification into the claims themselves, then that essentially gives the patent examiner a green card to go forward and do another search even mid-cycle. So there's some timing and some strategic things. The bigger thing is not necessarily about going back and forth on the written record. Almost every single patent office action or rejection that you get from the patent office, my suggestion is to get the patent examiner on the line. Call the patent examiner up. Say, hey, you've rejected this. I think there's a misunderstanding here. That is not teaching the invention, and I'd like to move the case forward. Those are the golden words that the examiner wants to hear. We are interested in moving this case along. The more you're interested in just fighting, then the examiner will often just dig his or her heels more into the mud, and no progress is being made. But if you come to the call and say, we want to hear you out and we want to move the case along, there's almost 99.9% of the time, it does move the case along. So I really recommend that you reach out to the examiner or have your attorney reach out to them in that manner. All right, going on to the next question. What if the product is a piece of software? How can we protect it? That's a great question, and it's one that I deal with often. I in fact have many software companies that I've assisted with. Software itself can be protected as often a method or a method of processing. Now, software is always kind of in this ambiguous zone of, well, is it patentable or is it not patentable? And there's been all these strategies over the last 20 years of modifying the claims to put them in a way where they, in fact, can pursue software sets. So software is currently protectable within the US. So the question is, well, what can you do with respect to software? Two different aspects. One is you can think of it as a data flow and how it is that the data flow is occurring and changing. So if you simply have data in, data out, think of what the data is doing in transformation from the in to the out. So data flow, again, think of it from a transformation point of view. The other thing, and by the way, the more intricate you can look at as far as the transformation of the data and the data as it's flowing from one to the other, the better. So intricacy does matter. And perhaps even more so is looking at the effect of software on the physical world. And so that is where it is that the courts have been focusing a lot of their time and attention, and that is, how does it actually affect what's going on around us? If we simply have a software set where you have data going in, there's a black box and data coming out, how does that really affect anything? So the more that you can show that the software has an effect, let's say on processing speed, or showing how it is that it affects battery life, or showing how there is a great reduction in the amount of cycles that are required as far as processing, the more that you can look at how it has an effect on the physical world, the physical hardware components, circuitry, things of that nature, a more efficient and effective circuiting type processing system. The more you can look at it from a hardware perspective of how the software is affecting it, the better it is. Almost all software inventions nowadays not only look at it from a data flow point of view, but also how is it making the hardware components work in a more effective and efficient manner. So those are two things that I would look at. Can I understand that infringement is invasion? Well, going back to my castle analogy, I guess it is some type of an invasion. When we look at infringement just simply means that the claim that was allowed, all limitations of that claim have been met. So going back to the claim chart that I provided, if we do not have each and every single limitation being shown by actual evidence of that infringement, then there is not infringement. And so if we go back to the slide on that, if we look at this chart or this table, let's say that the legs are in fact slanted in. So they're not directly straight down, but they're slanted in. That type of table would not be infringing here because the claim specifically said are mounted in a direction orthogonal to the surface, and orthogonal is 90 degrees. So if it's anything more or less than orthogonal to that surface, it would not be infringing. Infringing just simply means that somebody is making, using, or selling a product or a method that is meeting all elements of your claimed invention. So if all elements are being met by your claimed invention, then yes, it would be something that would relate to that. All right, next question. The question is, can I protect registry of my products? I mean, registry protection of patent or invention in America. The registry of your product, so there's two different components going on here. Often you have what's called disclosure of your invention itself, and then you also have the protection of the invention yourself. So disclosure is just how it is that you disclose it to the world in some way, shape, or form. That may be via an official registry, it may be at a trade show, it may be in a publication, etc. So disclosure is usually what it relates to a registry. Regardless of whatever disclosure occurs, you can also have a filing, and that filing is of your invention, and that allows you to establish that on such and such date, you disclose to the government what your invention is, and they essentially stamp that and said, hey, inventor has disclosed this invention on that date. That is often what, in looking at the overall disclosure process, I often recommend companies to go ahead and at a minimum, get something on file, which is normally called a provisional application, so that you do not have to rely solely on an NDA with the companies that you are in discussion with. An NDA essentially is a contractual dispute if there are any issues. You violated the terms of the confidentiality, but then it becomes a contractual dispute of did you or did you not? And if you did, they may slap their wrist and say, hey, you owe them some money for that. But on the other hand, if you pursue patent protection and you're relying on patent protection, rather than just a contractual dispute, you can have access to the actual damages that the other company got off of making, using, or selling your patented invention. So usually looking at the timing of disclosure and filing, you usually want to get something on file so that when you are in talks and the negotiations with other companies, You do not have to rely solely on the NDA, but you can rely on the initial filing. This brings up a different point, and that is, when you file for patent protection, you do not have automatic rights. All that you have is literally a date stamp of what it is that you disclosed on that date. But it's not until you finish going through the entire patent prosecution process that you get potentially a patent issued and granted, or granted and issued. And it's at that point, once your patent actually issues, that you have protection, that you have something that you can base your patent strategies on, whether that's core technology, offensive, defense, marketing type approach. So anyway, those are two different aspects of relating to that within America. Next one is, if you have a patent in a certain country, how do you expand that to the rest of the world? First off, I think it's important to note that there is not a global patent. Patents exist on a territory by territory basis. So based off of that, when we are looking at patents themselves, patents, you will have a patent with, for example, within America, within Australia, within Germany, within India. They are geographically specific. If you want to go ahead and pursue international protection, there is a common vehicle for that, which is called the PCT application. The PCT application is essentially an application that stands for Patent Cooperation Treaty. It was this treaty that was established a long time ago that essentially a lot of countries, most countries, came together and said, we agree upon a systemized common application. And so what happens when you file a PCT application is you file it, that is sent to WIPO, World IP Organization, and they handle the processing of it. In part, you have a receiving office. A receiving office can essentially be any patent office in the world, or a select of them. And once you have it in this vehicle, namely that it's in an international patent application, after 30 months, so almost 2.5 years, at that point, you have to enter into the specific countries that you want. So you file, usually how it works is you file a provisional application, for example, within the US, or within another country, a provisional or an actual application. Within the year's time frame of that initial filing, you then file the PCT application, because there is a 1-year grace period by which you can file for international protection. So at that 1-year mark, you file for international application, and then you can sit on that for another 1.5 to 2+ years while it's just simply going through its normal process. And then at that point, you can choose which countries to go. Now, note that international protection can be very expensive because, for example, if you go into Asia, you have to cover translation costs. And those translation costs can be very expensive, especially if you have a portfolio and you're pursuing all things internationally. So translation costs can be expensive. What are called annuities can also be expensive, and that's where you have to renew your patent in order to keep it valid in different jurisdictions. So once you have a patent in a particular application, you can also use a different vehicle, which is called Patent Prosecution Highway, PPH. And that allows you to take the prosecution that occurred within a singular country and essentially say, look here, we've already gone through prosecution, new country, please apply that prosecution in your review. And that's exactly what they can do. Some countries like PPH more, others do not. But you can, once you have a granted asset within a country, you can still use PPH for purposes of trying to go to other countries as well. So again, that is in relation to validity. Validity itself is the testing of a patent to determine whether or not it can be upheld at a later time period. And issuance of a patent is the basis, for example, PPH going into other countries. But again, you have to go into individual countries because each country has their own laws regarding patents. The question is, I missed the part about making the claims extendable and alive, wording in the claims, or continue by adding the claims. So the claims are kept alive based off of whether or not you keep the patent application alive. And what I mean by that is, once your claims are set in stone, meaning that you have an issuance, of the claims. Once the patent grants and it actually issues in a published format, your claims are essentially set in stone. They really cannot be modified much thereafter at all. So then that next arises the question, well, what if you need to modify your claims later on? If they're set in stone, they're set in stone. You really can't modify them very much. That's the whole reason why it is that you file a continuation application, because it essentially restarts the whole process. You can go ahead and modify the claims as you want, as needed through that entire process. So in essence, if the goal is to get to that 10-year mark after initial filing, because again, that's where we're reaching some of the peak in value, then what we do then is file an initial application, we file a subsequent continuation, and we file another continuation and another continuation, however many is necessary to keep that patent portfolio alive. And you may be sitting there thinking, well, can that get pretty expensive? If I file 10 initial patent applications, that means I may be potentially keeping 10 different patents alive for 10 years. In other words, very, 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 very expensive. Now, there are some cost-effective ways of doing that. You can have all of these continuations and bundle them down to what's called a continuation of part. And that continuation of part can claim priority to all of these different discrete inventions, assuming that there is a common basis for the inventions or the inventorship. You can then combine them together. So rather than keeping 10 patent applications alive, you can combine them together into just a single patent application, and you just keep that single one alive for 10 years. And then at the 10-year mark, if you need to spin off continuation claim sets directed to any of the preceding 10 applications to which it claims priority, you can still do that. That's a very complicated way of simply saying there are cost-effective ways of minimizing the cost, but keeping your options open. So keep that in mind as you're going through that as well. Next question. So the next one is, in the case of an app product, should one file a common or individual patent application, for example, mobile, desktop, other modes of use? And this goes back to the land type aspect that we were looking at before. You want to make your application as robust as possible. And that is very much the case. So when we're looking at this, you want essentially one common patent application that describes all the different modes, that describes all the different manners of the different interaction, whether it's on a mobile device, desktop, making one assumption, and that is if the app itself is common to each of these different types of platforms, then you just bundle them all up into a single comment. If your app is different on each of these different platforms, then that interaction potentially may want to be spun off as different patent applications. But I would also argue that you can potentially just bundle that all into one. For example, if you were to pursue each patent application individually, I mean, common rates for a patent application are $10,000 to $11,000, so it's very expensive. If you were to pursue 3 different modes, you're looking at $33,000. But if you go back to your patent attorney and you say, all right, we've looked at one mode within this particular application, there are 2 other related modes to this, and I would like you to spend an extra 10, 20 hours fleshing that out within this particular patent application. You go from spending $33,000 to spending a little bit more, let's say $5,000 more on that one single application, but you bundle it all into one package. If you go back to the patent attorney, a lot of patent attorneys are just paid on a flat rate. And so what they're often thinking is, how can I get in and out as quickly as possible? And so from that point of view, if you go back to them and say, I'll pay you your standard rate, but I want you to spend an extra, 10 plus hours really thinking outside of the box, and I'll reimburse you another $1,000 or $2,000. You can negotiate that. My point is, it's easier to negotiate that and build a more robust specification than simply going to them and saying, hey, can you do 3 applications for me? If you go to them and say that, they'll say, absolutely. It's more money for them. But if you can just focus on bundling that into one, overall, you'll have more cost savings for you. You will not limit
what type of claiming you can do. If it's all one common spec, you can spin off as many different claim sets as you want directed to each of the different use case scenarios that you have. So common spec, make it as robust as possible. That kind of attaches and coalesces together everything in relation to that. Yes, as far as a recording of this, it is being recorded and it will be provided after the lecture. Any other questions? We are almost out of time. So if I did not answer your question, please go ahead and respond. Wonderful. Well, it's been a pleasure being with you today. If you have any further questions, let me know. You can always reach out to me at the email that was indicated in the slides. And again, I will send those slides on to be distributed to the team as well. It's been a pleasure being with you. And good luck as you seek to protect your intellectual property. Thank you.